Hey everyone, welcome back to the channel. Today we are going to talk about something very important for investors in private companies: how to protect yourself from minority oppression. Being a minority shareholder can sometimes feel risky, especially if the majority shareholders control most of the decisions. But there are legal steps you can take to safeguard your rights. In this video, we'll dive into what minority oppression is, why shareholders' agreements are crucial, and what salient terms you should include in these agreements to protect yourself. Let's start with the basics. What exactly is minority oppression? Minority oppression occurs when the majority shareholders who control the company use their power to make decisions that are detrimental to the minority shareholders. This can include anything from squeezing out minority interests to withholding dividends or even selling company assets without proper consultation. In Singapore, the law provides remedies for minority oppression under Section 216 of the Companies Act. This section allows minority shareholders to seek relief when they are unfairly treated. However, legal battles are costly and time-consuming, so it is always better to take preventive measures before issues arise. One of the most effective ways to protect yourself from minority oppression is through a shareholders agreement. This is a legally binding document that sets out the relationship between shareholders of a company. It governs how the company is run, and most importantly, it protects the rights of minority shareholders. Why is this agreement so crucial? Because without it, the default rules found in the company's constitution may not adequately protect minority shareholders. A well-drafted shareholders agreement can address potential areas of conflict and ensure that the interests of all shareholders are taken into account. Now let's talk about the key terms that should be included in the shareholders agreement to protect minority investors. First up are the reserved matters. These are decisions that cannot be made without the consent of both the majority and the minority shareholders. For example, decisions involving the sale of major company assets, changes to the company's constitution, or issuing new shares. By including reserved matters, minority shareholders get a say in significant company decisions. The second most important term to include in a shareholders agreement are preemption rights. These rights give existing shareholders the opportunity to buy new shares before they are issued or offered to external parties. This prevents the dilution of minority shareholders' equity, ensuring that they maintain their percentage ownership in the company. Number 3, have a clear dividend policy in your shareholders agreement. Majority shareholders could otherwise withhold dividends, depriving minority shareholders of profits. Majority shareholders can also pay themselves huge directors' fees, leaving very little profit to distribute by way of dividends. By setting out a clear dividend policy, you can ensure that profits are distributed fairly and regularly. Number 4, include drag-along and tag-along rights. Drag-along rights allow majority shareholders to force minority shareholders to sell their shares if a third-party buyer wants to acquire the entire company. Tag-along rights protect minority shareholders by allowing them to join in the sale if majority shareholders sell their shares, ensuring that they get the same price for their shares. Finally, an exit strategy is crucial. Include provisions for how minority shareholders can exit the company, such as buyout rights or put options, which give minority shareholders the ability to sell their shares at a fair value if they no longer want to remain in the company. So to wrap things up, while the law in Singapore provides protection for minority shareholders through Section 216 of the Companies Act, it's far better to proactively protect your rights by having a well-drafted shareholders agreement in place. If you're an investor or thinking of becoming one, don't hesitate to seek legal advice to draft a proper shareholders agreement. After all, prevention is better than cure. Thank you for watching, and if you found this video helpful, don't forget to like, share, and subscribe for more legal tips. See you in the next video.